of YXA and Wolverhampton City Council and YXA and Surrey County Council part heard.
Yes. Morning, my lord. Morning, my ladies. Lady. My lord.
Try again.
Good start. I wonder if I could go back to something briefly, which is the supplemental bundle. I took the court briefly through the particulars of claim in the Poole case. So there's just one thing I'd like to go back to, if I may. It's a supplemental bundle in YXA, and the particulars of claim begin at page 62.
Right. Now, let me make sure. Why? Supplemental.
Supplemental bundle, right? You probably.
Well, I'll just shut up. Okay, so so again, 62.
62 is where it began. I took the court to the particulars of claim and certain parts of it, but I omitted another part which I just briefly like to take the court to, if I may.
Right.
And then that's the sequence of events which we get at the bottom of page 64. We can see there helpfully the summary of what are described as the key dates relating to the background events. Beginning, of course, with the claimant's mother being born. We do actually.
Can I just ask you this? Is this a common form for pleadings these days?
I'm not sure there is a common form, but I think it's a form that's quite often adopted by claimants in these type of cases. Okay. And perhaps, in answer to that point, I think during the course of my learned friend submissions, there was some question about not having the Section 20 agreement to hand.
Yeah, I think I said that.
Yes, I think your Lordship did say that. In fact, of course, we ought to make it clear that there is always pre-action disclosure in these cases, so that the claimants do have every opportunity to plead their case as fully as possible.
So they don't get the whole file, though, I presume?
They get all the file that's available.
They do?
If they don't, they can always ask for more, because it's accepted, of course, that a claimant wouldn't necessarily be able to tell without those documents what the nature of their case might or might not be.
I mean, what's striking to someone, my professional background, as you know, Lord Fawkes, is not in the area of the law where I've done much pleading over the last 40 years, but it's a big change from how documents were pleaded when I started out. It's they're much more expansive, much more discursive.
I think they are, and I think there is a question of individual style slightly in these things.
Of course.
But I think since the CPR really came in, there was a requirement, certainly in defences, which was supposed to be far more specific as opposed to those blanket denials, unhelpful denials that one used to encounter when we first started at the bar.
Okay, all right, enough.
Anyway, perhaps I'm not going to ask the court.
You want us to do the sequence of events?
Sequence of events. And I'm not, of course, asking the court to read it all. I'm just going to take, if I may, just one or two highlights to show the sort of general area in which the social workers were involved. So that if we go to page 65 at a 9/11/06, we have a core assessment carried out by the first claimant's needs. And then page 67, we have a 24/11/09. The social worker who undertook the assessment of the needs reported to the manager the second claimant's case required urgent transfer for a core assessment to be undertaken. Then down the page at 14/5/10, the strategic manager of Children's Services acknowledged the initial assessment. A further assessment was planned. And then if we go to page 69, we can see there at 20th of June 2011, a child protection strategy meeting was held. Then on the 11th of July, an initial child protection conference made a decision. And then on the 9th of September, a meeting was held in respect of concerns in respect to the claimant's mother's care of the first claimant. And then on 6th of October, a review of the child protection plan, the second claimant. And then the family moved on the 12th. So what I'm endeavouring to show by that was this was fairly standard sort of procedure that goes on when social services are investigating.
The difficulty with that is you've got to consider, as my lady said yesterday, assumption of responsibility for what? And those things might not indicate an assumption of responsibility to protect children from other families on the estate who might threaten this child. But when you get to a different factual and legal context, i.e. harm within the family, a willingness to accept or an investigatory role when a child tells you my father's been touching my private parts, or when they recognise that and they decide to do keeping safe work. What Ms Gumbel is trying to say, I think, is that's different. We just don't know whether having a child conference would be an assumption of responsibility there, although it may not be an assumption of responsibility vis-a-vis harm from other children on the estate. That's the thing that's missing, really. You can't just say Child Protection Register Conference. Child Protection Register Conference for what purpose?
Yes, Lord, indeed, I do recall that exchange yesterday, and certainly there's nothing in the decision in Poole which distinguishes between the potential risks that might exist towards a child. There's no factual distinction we submit in any of these cases between, for example, abuse or neglect within the home by parents or carers, abuse within the home by siblings, abuse within the home by visitors, for example, a mother's boyfriend or friends of siblings, or abuse outside the home by relatives, friends, uncles, aunts, grandparents, child members, or abuse outside the home by others, child exploitation involvement, or child prostitution, unsuitable friends, the whole range of different risks. There's nothing to distinguish that in the ratio. That's our submission in answer to that point.
But the ratio is only on the facts of the case. There's old comments by Lord Wilberforce, it's a very wise judge who limits what he says to the facts that he's dealing with. You can't assume it's dealing with all sorts of other things. We just don't know, do we?
Well, my submission will be, and I hope to make this good by one or two references, not too many references, I can assure the court, is that, of course, a court concentrates on the particular facts before them. But it's quite plain that the Supreme Court, Lord Reed, with whom all the other judges was seeking to set out what the law in this area was.
Yes,
we submit,
but not how it applied to the facts of particular different contexts.
Well, I mean, that is why, in a sense, we submit that what he was saying when referring to the possibility of assumption of responsibility was simply never say never, because, of course, there might be situations. But the broad thrust of the decision, we say, is clear. It is dealing with a huge majority of cases which come within the many different activities which are undertaken by social services at various stages. And whether it is Poole or whether it is either of these two cases or whether it's the Mrs Justice Lambert case, there are lots of different things that social workers do or don't do in the course of their exercising their statutory powers. And of course they are essentially a regulatory agency, which is one of the reasons why I think there's always been a comparison between a doctor or even an educational psychologist. They are regulating a number of different factors. And of course the statute actually suggests, section 17, that the local authority should be striving towards supporting the family, to continue the child within the family where possible. So these are difficult decisions that courts ultimately have to make, and social workers working often on imperfect information that they may be provided will go through various different exercises in order to try and act in the child's best interests. Yesterday it was indicated to me that the court, and I wholly understand this, hadn't in fact had a chance or availed themselves the opportunity of reading the judgments of the masters, and I don't want to...
No, we have read the judgments of the masters.
You have?
But we didn't go through them.
Right.
That was the point I was inelegantly making. So I think it would be helpful if there is anything you want to draw to our attention.
A couple of passages, yes. That's all I want to take to. So if we could look at the YXA file first of all, and at page 161. Deputy Master Baggett does in fact go through a very thorough examination of all the authorities, and I'm not going to go over that. But what I am going to do is to go to the his conclusions, which I think are helpful. So it's page 161. And at paragraph 45, does the court have that? One can have nothing, he says, but sympathy for the shocking and long-standing abuse which the claimants endured as children, and may I echo that on behalf of my clients. I must make my decision based not on the sympathy I feel, but on the legal principles which apply. My task has been to determine whether there are viable claims against the defendant, local authority arising out of their child protection activities in relation to the first claimant. In the circumstances and for the reasons discussed above, which he discussed at some length in the course of his judgment, the relevant claims are, in my judgment, bound to fail as there is no arguable duty of care. Where there is recent Supreme Court judgment which is on point or at least closely analogous, I do not accept that this can be described as a developing area of law or a developing point within that area. Such a conclusion is not inconsistent with other aspects of the views of claim that still develop. I reiterate the learning from Robinson about the importance of precedent, of maintaining the coherence of the law and avoiding inappropriate distinctions. Were I to accede to the first claimant's response to the application here, I consider that I would be making inappropriate distinctions to avoid applying a clear precedent from the highest court. That's why I submit, amongst other reasons, it is a clear precedent, thereby allowing legally flawed claims to continue past the interim stage. To do so would be no kindness to the first claimant, only for the relevant claims to fail at trial, which of course happened at Mrs Justice Lambert, as I consider inevitable. Better to focus on an arguable allegation, upon which it would be for others to rule on another occasion. It would also be contrary to the overriding objective to permit the relevant claims to proceed, as it would result in significant further costs and court resources being expended. And then he says importantly at paragraph 47, in reality, whilst there are naturally some factual differences, there is much overlap in the process of monitoring, investigation and assessment carried out by the local authority in Poole and the present case. Poole cannot sensibly be distinguished from the case in terms of the appropriate legal analysis to be applied to the respective factual matrices and considering the question of the duty of care. That we submit is a very succinct summary of the correct approach in this particular case. We have in our skeleton argument at page 14 of our skeleton referred to a number of other passages in Deputy Master Baggett's judgment. That's at paragraph 40, page 14 of our skeleton. I'm not going to take the court to them, but may I respectfully request that were the court to want to revisit the judgment of Deputy Master Baggett, those references may be of assistance.
Thank you.
And then Master Dagnall, this was the YXA case, which is, begins at page 263. The relevant passage I'm going to take you to. This is a very long judgment.
It is.
Approximately 100 pages.
Yeah.
One of the reasons it is lengthy is, of course, there is a lot of citation from authority, which takes up quite a lot of the judgment. I can reassure the court I'm not going to go through all that. However, there is, I think, from on page 263, a useful passage which I think deals with one of the points that I think my Lord or Justice Lewis is testing me on, which is paragraph 81. I also note Mr. Levinson's submission that N versus Poole is simply distinguishable because it was held there was nothing pleaded which could have amounted to a breach of any duty of care. It is correct that the claim would have failed on that basis in any event, paragraph 90. But it seems to me to be clear from both paragraphs 89 and 91 and the rest of the judgment that the Supreme Court also proceeded on the basis that nothing had been pleaded which was sufficient to have given rise to any duty of care in the first place, and so that the question of breach, had there been an existing duty, strictly did not arise. And I'll make good this submission when I go back to looking at those relevant paragraphs in Poole. I therefore turn to the question of whether there are reasonable grounds pleaded for a general duty to investigate and take proceedings. And he said at 82 little 1, it seems to me there is nothing materially different between this case and N versus Poole, so he comes to a similar conclusion as Deputy Master Baggett. On the pleaded case, the defendant had, or should have had, this knowledge of significant harm and the power to intervene. The same existed in Poole, but that was held as insufficient to amount to an assumption of responsibility. And paragraph 81 made it clear that even a decision to investigate was not sufficient to create any duty. This, like Poole, is a pure non-intervention case, where the ability to intervene existed, but where it was held that no duty existed to take steps to confer a benefit by way of protecting from harm from others. That sums up, we say, succinctly.
That begs the whole question that the one big factual difference here is they had recognised that there was a risk, so much so that they themselves thought that at least for 4 days a month that child had to be taken out of the risk. And the question then arises is, should that, treated as an assumption of responsibility, not just to protect him from that risk for the 4 days when he was in the accommodation, but to consider whether it could safely be returned or whether the 4 days should become 6, 8 or more. That's the difference. The argument is it's not pure intervention. It's only pure intervention if you analyse it in one way.
I accept that's one of the points. It's the section 20 point, and I will be dealing with that in due course. But it is, perhaps the only point.
No,
but we say it isn't, of course, but Your Lordship's quite right to raise it with me. Now,
is Master Dagnall right to say in paragraph 82 of Roman 1 that local authority had the power to intervene? I thought we just agreed that the local authority didn't, because it couldn't have taken the children into care on those facts.
Lady Justice King.
yes.
Yeah.
Well, on those particular facts, of course, I entirely accept, and this was a point that was raised yesterday. When I come to look at Poole, what I will be submitting is that if one looks at the judgment, not only those paragraphs, looks at the judgment overall and indeed the conclusions, it's quite clear that that was an additional reason, but it doesn't undermine the analysis which the Supreme Court formed in relation to...
Well, my question is about Master Dagnall's analysis.
Yes.
Isn't that a little bit shaky in that subparagraph?
Yeah. Sorry? Excuse me. Yeah. Appellant Junior reminds me it's a power to intervene, albeit in a lesser way. I mean, there are powers to intervene short of actually going as far as they might have done. Given
But the reference to the knowledge of significant harm or the risk of it looks like an assertion of the knowledge of the grounds for statutory intervention. It's not quite how it's, you'll recall the test for intervening in public law cases being significant, is suffering or is likely to suffer significant harm.
And would it matter in the following two circumstances, as I put to Ms. Cameron, if they drove the child back to the house, the social worker took him back from where he'd been for the weekend, and they got to the house, the lights were out, the doors were locked, the neighbour said, I haven't seen them since Friday. Are you saying then that there was no duty of care and they could just leave the child there?
No, and in fact, I think Master Dagnall deals with this point, in fact. One goes on to page 268, paragraph 90. This is what has sometimes been fairly loosely referred to as respite care in the context. I think that was a contested...
Well, that was, I introduced that phrase. Don't worry about that.
But I think... I think Your Lordship...
If it's a distraction.
I think Your Lordship's unnecessarily pleading guilty to that because it was in fact introduced during the course of the argument.
Yeah.
But in shorthand, that's what was used. But I think the paragraph 90 was talking about what duty, and I think this answers the noble, Lord Justice Lewis. Not noble yet. Yeah. With regard to this, it seems to have been common ground, and rightly so, that during the period that the claimant was being provided with respite care, the defendant owed some duty of care, and this would extend to the mechanics of the return, e.g. the driving of the claimant back to the parents' house, or the claimants to the parents. That perhaps answers the point about the
Here's
right
an
to bring
example.
up.
They've taken this child into care because the parents aren't coping and they're medicating him and hitting him too much to keep him quiet. That seems to be the gist of the particular claim. On the way back, the child turns to the worker and says, please don't take me back. It's not the hitting, it's the sexual abuse. My father's abusing me day in, day out, and my mother's helping him. Does the social worker owe no duty of care? They've taken the child in because they think there's a risk and he needs at least for some days to be separated. The child tells them, it's worse than you think, it's not physical, it's the sexual. And the social worker says, oh, well, I'm sorry, that's nothing to do with me. That's all right, is it?
I'm not saying it's all right, of course.
No, it doesn't give rise to duty of care.
There are all sorts of things that, with the benefit of hindsight, laws might have been available. But the question is whether they're doing something more than simply, in any particular factual situation, something more than what is their general role, which is provided for by statute. The point about the Section 20, I think the argument below was, since there is some sort of duty, clearly when you're temporarily housing someone, whether it's called respite care, whether it's a day or a week or whatever it might be, in terms of the safety of the building, for example, or taking them back by car or whatever, can that be enlarged into saying, right, since you have some duty there, you have now got a duty of care towards this child generally, which means you can, as it were, circumvent the apparent absence of the duty which Poole
The way to
provides.
put it is, does the circumstances giving rise to your decision to intervene mean that those facts are also capable of giving rise to assumption of responsibility to do anything else? You've assumed responsibility to the child, at least to protect against one risk for some days. Does that amount to an assumption of responsibility to guard against that risk on other days, or new risks which you learn of during the period of accommodation? That's how it's relevant. It's not a duty to do one thing, it's the facts trigger an assumption of responsibility.
Well, I think this perhaps comes back to a series of questions that were posed by the court yesterday by my Lord Justice Bacon and Lady Justice Laing, which was, how long does the assumption of responsibility last? What is the assumption of responsibility for?
Yes.
I think that one can get a little, perhaps respectfully say, a bit sidetracked by the word responsibility, because of course one naturally thinks that somebody might be responsible for a child in circumstances such as your lordship proposes. But assumption of responsibility is a term of art used to describe where in normal circumstances there is no duty, and that must be the primary position. I don't think anybody can argue otherwise. Because it's something more, because it's something exceptional, then there is a duty where otherwise there would not be a duty. We would respectfully submit, whilst I hope not avoiding the question, but going into minute analysis of precisely when a local authority did something or didn't do something, whether they might have done this or might have done that, is not saying, oh, we can find an assumption here, we can find perhaps was there an assumption there, and of course the logical of that argument is that eventually you can't strike at anything because who knows?
The contrary position is unless there is a clear line, you can't strike it down.
Yes.
I mean, so I think that's, well, you can tell this is an area we're all concerned about. Is there a clear line in these cases which indicates where assumption of responsibility occurs, so that you can say at the outset of any litigation, yes, this case comes within the scope of the duty, or may do, or it doesn't?
Well, obviously I rely on what Mrs Justice Stacey and the Deputy Master said, and indeed what Mrs Justice Lambert said. Well, it is sufficiently clear here. There has to be something more which takes it outside the normal run of cases, albeit, as I hope I've made clear, that there will be variations on the facts. But I looked at
But something more isn't a very precise. I don't criticise Mr. Justice Lambert, but something more isn't a very precise phrase, is it?
No, but it does come. It'll come from this court and and I'm going to take you to this case.
Okay.
The origins of it from the then Master of the Rolls in dealing with a case which had considerable parallels, when he essentially said there will not be a duty unless there is something more. Now, of course, courts are unwise to say what something more may or may not be, but of course, by not being specific, they always leave open arguments to say, well, maybe there's something more here. But when one looks at it, the way the court looked at it in X and Y and Hounslow, something more doesn't just mean.
Well, we're going to come on to that. Yeah. But just so we're clear, obviously, responsibility is a phrase, is a word that's used in the Children Act for very specific circumstances, even parental responsibility.
Yes.
And the local authority acquires parental responsibility when a care order is made, either an interim care order or a full care order, and in no other circumstances. As I understand it, it's not your case that that's what responsibility means here. It's only when PR is, you're not saying it's only when PR is granted to the local authority that there is an assumption of responsibility.
No, but assumption of responsibility, as I said, is a term of art. It doesn't mean responsibility in the sense of the responsibility of the local authority in the position that your lordship has put out. It is a, coming from Headley Burn as it did via Spring and Guardian Assurance, used in other cases, it means a specific circumstances in which the courts have decided. Because it's not someone actually assumes responsibility voluntarily. The courts have decided that the facts are such that the court should conclude that there was an assumption of responsibility. Coming in Headley Burn, the more or less akin to contract type situation. And then it's a fairly narrow path, is our submission.
Yeah. Okay.
And it's
we're a long way, it seemed to me to be a long way from Headley Burn. And,
of course,
and advice cases.
We're a long way from Headley Burn, and I think I submitted yesterday that I thought the police cases were probably closer because we're dealing with a public authority, as to which there is prima facie no duty of care in their investigative role, but there may be circumstances of an assumption of responsibility.
Okay, all right. Well, we're distracting you. Carry on.
Well, I hope I've...
Have you finished? It has been helpful. Thank you. Have you finished looking at
I was dealing with
Master Dagnall?
Paragraph 90 about the mechanics of the return, hoping to provide some help on the point. What he says is, it seems to me that period or periods are clearly timed. This is halfway through paragraph 90. When the defendant has assumed responsibility by positively receiving the claimant into their control, and that the DV versus East Berkshire would apply in principle during those times. I do not have to, and therefore do not make any decision regarding the extent of the duty of care, for example, how it might be applied in terms of taking care to ensure the claimant was accommodated properly, with those who would take good or not bad care of the claimant, or even as to whether the defendant could or could not delegate, i.e. by employing an independent contractor, to take the claimant back to the parent's house rather than by using staff. Such matters are not for. He then goes on to consider section 20. Those are matters which we set out helpfully, I think, in the paragraphs that follow. They remain in our skeleton argument. They were dealt with by the judge, what we say about section 20. Can I just go to page 272 in the bundle, where he sweeps up what is a useful analysis and says, little 6, looking at the matter in terms of assumption of responsibility, the responsibility which was assumed was in relation to the provision of accommodation and matters linked to or flowing from that, not in relation either considering and taking care, etc., proceedings, or the position or the future once the provision of the accommodation had come to an end. So that's why he's narrowing it down. And then he goes on, the next paragraph, helpfully to set out.
Sorry, can I just read that?
Yes.
Again. Thank you.
Because this, I think, was described as a piece of reverse engineering argument, whereby I think it had been argued below on behalf of the claimants that if you've got an assumption of responsibility in these circumstances to this limited extent, you can then you open the door and you say, because of this, therefore the defendant owes a duty of care via the assumption of responsibility route more generally to do what it is said they should have done, i.e. to take the children into care. This says that is not the case, and we submit that's a correct analysis. And the next paragraph, little 7, is where he deals with section 20, the scheme of section 20, and of course we have all the, we've summarised the provisions, all the provisions are in the bundle, so I won't take the court to it. It requires and is controlled by the consent of the parents, that's of course crucial. This is the case both in terms of the initial provision and throughout the provision. At first sight, the concept of the defendant's undertaking a duty of care, which would extend to taking care, etc., proceedings against the parents, by virtue of the parents having allowed the local authority to provide and to continue to provide the accommodation, appears incongruous. Further, while the provision of the accommodation in these matters would not prevent the local authority from deciding to institute care proceedings while the accommodation was being provided, it would again be incongruous that the parents, by consenting to a provision of accommodation, a term which they could always remove the child from the accommodation, were allowing to come into existence a duty which would not otherwise not exist at the local authority to at least consider whether to launch care proceedings so as to prevent that removal. The duty which is sought to be imposed seems to be at least somewhat inconsistent with the statutory scheme.
Did Master Dagnall consider section 22?
He goes on to consider that at paragraph 97. I've considered the particular statutory provisions within section 21C,
22.3,
24 and 22.3.
Yes.
So I think that's the answer.
And
And he says at little 4, top of page 275, although section 22.3 imposes a statutory duty to safeguard and promote welfare, first, the general principle is that the statutory duty does not give rise to a common law duty without more. Second, I regard it as limited and controlled by matters and timing regarding the provisions of the accommodation. And third, this is all subject to the continuing consents of the parents. I therefore do not regard them as being sufficient to take into account my conclusion.
again, just give me a moment.
Yes.
Yeah. So the first is the general point.
Yeah.
Second, he says that the duty, the statutory duty under section 22.3a, is limited and controlled by matters and timing regarding the provision of the accommodation.
Yeah.
So he's saying that the duty under 22.3a only applies, is he saying this? While the accommodation is being provided, or in relation to the provision of accommodation.
You can't, in other words, you can't extrapolate from any duty that exists to say that there is a general duty of care, which is what he says in the following paragraph. I therefore do not regard them, i.e. the provisions that he's been discussing, as being sufficient to take me away from my conclusion that there is no general duty of care at common law to consider, etc., care, etc., proceedings during the provisions of the respite care accommodation.
Well,
so that's what he said.
Well, I don't want to say the hair running and take up a lot of time, but I'm just wondering whether we need to look at section 2022 at some point to consider if he's right about that, because this really goes to that's on one view that's the answer to my Lord's point.
Well, I mean,
Isn't it?
this claim,
is Master Dagnall right?
well, there's nothing about this case which is really to do with the inadequacy or otherwise of the respite accommodation.
No.
It's not concerned with.
No.
So the question is whether the fact that they recognise that there's a risk and they themselves thought they should take some responsibility for at least some of the days in the child's life indicates that that gave rise to a state of affairs where the court would impose a legal duty to take responsibility in respect of other aspects of the child's life, putting it in words that avoid the loaded words.
Well, with respect, of course, all the various processes that a local authority may go through, and I've showed you in the particulars of claimant pool, and there are, in all these cases, there will be a concern and a risk. That's why the social services are involved in the first place. The question is the assessment of the risk, and the assessment of whether intervention, if so, what intervention is appropriate. So the mere fact that there is a risk doesn't change the overall nature.
The recognition and the taking into care, because they themselves say on 4 days of the month, we want to make sure that the risk doesn't arise. And the question then is, does that constitute the sort of circumstances where they should be treated as owing a duty of care? Should that risk or a similar risk materialise on other days?
Well, there might be all sorts of circumstances in which a parent says, I simply can't cope, I'd like some help or respite care during that particular time. This is part of what a local authority may do to support a family, as I understand. That doesn't change the overall nature of what the local authority which is doing, which is endeavouring to discharge their duties and exercise their powers in accordance with the legislation. So that to isolate particular moments, to say, well, there was more risk here or less risk here, is in our submission actually running against the decision in pool.
Well, I think we do need to look at 22. The other thing, but before we do, the third thing he says is this all is subject to the continuing consent of the parents.
Yeah.
Is the extent of the local authority's assumption of responsibility subject to the consent of the parents?
Well, perhaps we can look at the particular provisions. We have summarised them in our skeleton, if that's helpful, and they're also in the bundle.
I think it's better to look at them in the bundle. And I sent back the other red book, so I've still got my red book.
So the very
22.
first volume of authorities.
Yep.
And it's at page 11.
Yeah. So the scheme, 17 is the provision for services in the area and the general duty.
Yes.
Section 20 is in page 11.
Yes.
And section 22 is the general duty of children, of local authorities related to children looked after by them.
That's right.
And a child who is looked after under that includes children who are in their care, and that means subject to care orders, and who have been provided with accommodation. And the statutory duty under section 22(3) applies to all looked after children, both those who are subject to care orders and those who are being accommodated under section 20.
Yes.
Agreed? Mm-hmm. So, in what sense do you say Master Dagnall was right to say that the duty is limited and controlled by matters and timing regarding the provision of the accommodation?
There is a distinction between what is described as a general duty in the statutory concept, which is the headline of section 22,
Yep.
and whether or not it is appropriate for there to be a duty of care in tort, which are the two separate questions.
Yes, well that's the first point that he makes in paragraph 3 and 4.
And, of course, one can understand why Parliament has decided that there is a general duty towards children looked after, whether they're temporarily looked after or not. Parliament has decided that entirely appropriately. One can understand why. But the question is whether or not the courts ought to superimpose a duty of care. It having been held, I made this point yesterday, there is no actionable statutory duty. That is clear law. Mm-hmm. So that nobody, for example, can understand section 22, if it were to give rise to a claim for breach of statutory duty. And the courts have hitherto held that there would need to be some reason for imposing a duty of care. The exception, of course, being Barrett, which was a case when the child had been taken into care, spent almost its entire life in care. And that was a striking out case. So interestingly enough, there was never actually an exploration of the scope of any duty. It was simply said you can't strike it out because this is different. We have a child where the parents have assumed parental control. Therefore, as a matter of tort law, we conclude that it is arguable that there is a duty. But the fact that there is a duty set out in section 22, which one expects Parliament to say that there should be, does not give rise, we submit, to a duty. And if we look at section 22(3), yes, it says it shall be the duty of the local authority looking after. So that's the process of looking after any child to safeguard and promote his welfare, to make such use of services available, etc., etc. And one can understand exactly why Parliament provided that. But for the reasons that were given by all the judges in this case, we don't say that that translates into there to being a duty of care in tort.
Right. So you say that the duty. So you would say there is an assumption of responsibility. Well, do you say there's an assumption of responsibility for the period when the child is actually being looked after?
Well, there is an assumption of responsibility only to a limited extent, in the sense that, as in fact Master Dagnall said, as does Mrs J Stacey and all the judges concerned with these issues, well, it only arises in two cases. The safety of the child whilst being looked after, with the consent of the parents. And there is the duty provided by statute, not of itself actionable, but one can see that the courts would say, well, clearly there's a duty to provide a safe accommodation, so that if the accommodation was dangerous or something of that sort, then the courts will probably have no trouble saying there was an assumption of responsibility. But you don't go from the fact that from time to time a local authority is looking after a child rather than has taken them into care. Therefore, yes, now they've done that on one occasion, whether it's because the parents wanted to or because they thought it was a good idea with the parents' consent, you don't suddenly say, right, all bets are off, there is now a duty of care. But that's the argument that Lady Friend says.
If, in the not uncommon situation of a child arriving for respite care with a bruise, let's take a small baby who can't speak, with a bruise, the local authority, the fact that the child is there being looked after by the foster carers, might be longer than a day, might be for a week, would not lead to an assumption of responsibility.
It wouldn't lead to an assumption of responsibility which is the equivalent of there being a duty of care. Yes, there's a statutory obligation which we've referred to, the court can see, but that doesn't mean there's an assumption of responsibility except to a limited extent to look after the child. We don't
be a responsibility, surely, to safeguard the welfare of the child and to protect him from other people. The younger child in the foster care household who's hitting him, the foster father who's sexually abusing him. Surely there must be an assumption of responsibility giving rise to a duty of care to stop harm from others in the place where they put him, as well as the physical safety of the house and the building.
Well, with respect, in answer to that question, there's no difference really between being concerned about that in the general sense, whether or not it's information that they've acquired whilst the child's being looked after, or whether it's information they've acquired through visits or through case conferences or for whatever sources. One can understand why a local authority should be vigilant about these things to protect the child. Of course, that's the case. But the law is that there is no duty on the part of the local authority to prevent damage from third parties, however desirable and appropriate it might be.
If they decide to look after a child for 48 hours and they put them in a foster home, there's never been any problems, and on the second day the neighbour rings and says, you need to know this, the foster father's taken to drink, he's beating the children. Is there not then a duty to protect the child from the harm inflicted by the increasingly alcoholic stepfather, foster father?
In answering the question, I don't want to suggest that I don't think it would be appropriate for the local authority to do something when providing that information, or to assess it, to follow it up.
You say there's no duty of care.
But the question, there's a difference between what one would expect and hope a local authority to do, and whether there should be a duty of care. And therefore, we come back in the old analysis, X and Bedfordshire said there are policy reasons for the no duty. But now we look at Poole, and the essential fact is there is no duty to protect against the acts of a third party, into which category that would fall. And the fact that from time to time a child may or may not be accommodated in Section 20 does not detract from that essential proposition of law, which has been established at the highest level.
Yes. Well, obviously this is troubling us, as you could tell. So it does seem to come back to Poole in the end. You're going to end up there.
I am going to.
I'm just wondering, is there anything you want to say about anything else about Section 22?
No, I think everything is in our skeleton. I hope and he discusses it. I don't want to labour the point.
I mean, there are a lot of factual there are a lot of factual situations covered by Section 22. It covers all children who are being accommodated and all children who are in care.
Yeah.
So it includes children under the in their care provision who are in their care at home.
Yes, I mean, I of course defer to your Lordship's greater knowledge of how these things happen in practice, and of course there will be an infinite variety of different
And there are,
circumstances.
you know, understandably, we've not. The tentacles of the Children Act and the regulations are growing all the time. And of course, there are statutory provisions, regulatory provisions about placing children at home under care orders.
Yeah. And perhaps that just shows how complex the whole business is, which is what was one of the reasons why in Exton Bedfordshire they said this really isn't appropriate for analysis in terms of a Bolam type test, because of the fact that you're not providing a direct service, you're trying to regulate a very difficult, often but a complex situation where imperfect information is available and so forth. But on the other hand, there is nothing to suggest that the overall conclusion, which is reached in Poole, that there should not be a duty in these circumstances, is displaced by the fact that there are increasing number of regulations which deal with the many different situations that may arise.
Yes. Where do we go next?
I'm going to go briefly back to DFX, which is at tab 8. And I think I want to try and deal with the points that were raised by the court with my learned friend. It's at page 161. There was a great deal of focus on the particular 3 events which were relied on. This is at paragraph 16.
Yes.
The court will remember there was the commissioning of the report, the direct work and the assessment. And
do you agree that the direct work, contrary to what Ms Gumbel was submitting, that in fact we do not know whether the direct work does or does not give rise to a duty of care because of assumption of responsibility? Because when it came to it, there was no criticism and no allegation of breach. So we just don't know from the DFX judgment, if we were to read that alone, whether or not a direct work could or couldn't give rise to.
no, I mean she didn't
That's
have
the position, isn't it?
she didn't have to decide that.
She didn't.
At
It
all.
might or it might not. We just don't know.
Yes, I mean if we go to page 202, paragraph 200,
Yeah.
the judge says, I turn therefore to consider whether on the facts before me the defendant did assume responsibility to perform its statutory functions. Given the rather sparse way in which the point is advanced, I find that I can deal with the matter relatively shortly. She dealt with the Rayside report, which was the strongest point. I think we've probably gone into that sufficiently. She did not think that that amounted to, I respectfully submit that she was plainly right on that. And she did point out at 205, like Lord Reed in Poole, I see nothing about the nature of the statutory function which the defendant was exercised, which gave rise to a duty of care. Scumble's not pointing me in the direction of anything that was said or done in the context of obtaining the report, or in the context of the decisions made in 2002, which entailed that the defendant assumed or undertook responsibility towards the claimant to perform its functions thereafter with reasonable skill and care. The position is, I find, similar to that in Poole, and for similar reasons. So she found Poole helpful in the clear authority for the approach that she took. Notwithstanding that the facts of the appeals may be different in D and East Berkshire, on the direct work, it's dealt with at paragraph 210, and my Lord or Justice said, I acknowledge, referred me to this, I acknowledge that the claimants are critical of some of the direct work. Different considerations may apply. However, if a duty of care was generated by this work, the scope of that duty would be limited to performing the direct work competently.
What about failing to do the work completely?
Well, I don't have to argue this because it isn't, but I would submit even failing to do the work, because there are quite a lot of criticisms in these cases. The cases we have of failing to do something, having decided you wanted to do something, you didn't do it. If one goes back to Stovin and Wise and Gorringe, those were precisely those situations where there was an opportunity to do something, and the question was whether you should say, well, in view of the fact that they'd even decided they were going to do something in Stovin and Wise, they didn't do it, but the court nonetheless said there's no duty to do it simply because...
But isn't saying, well, okay, we're going to do some keep-safe work to protect YXA against the possibility of, to help her protect herself against sexual advances, isn't that assuming a responsibility for protecting the child from harm? I mean, you can tell the way I'm putting the question. I can, for my part, certainly possible in the language that's what it is to say at the very least.
I don't want to repeat myself, but with very great respect, I understand why your Lordship says there's assumption of responsibility in the sense of you're feeling you are responsible by law, in a sense, to look after the welfare of the child. That's not in dispute. But assumption of responsibility has a very special meaning in this context, which is rather different.
Yes.
And not doing something which you have the power to do, the non-exercise of a power. It is quite clear from House of Lords authority, and this has been referred to specifically by Poole, again, where they said that Stovin and Wise and Gorringe had been insufficiently understood in the past, does not generate a duty of care.
Okay, well, at some point it would help me if you could just briefly illustrate the authorities.
I will, and I think I can do it relatively briefly,
Good.
but they come from Stovin and Gorringe, which are specifically embraced, as it were, by Lord Reed in Poole.
Yes.
So,
If you go up a step, when we talk about assumption of responsibility, we're talking about the set of circumstances which the law thinks are sufficient to impose a duty of private care. So if you look at these circumstances, and you had a situation where, against the background of a specific allegation by a child of sexual assault by, I'll call him the father, I don't think he was the father, but the man living in the house. Against that background, a local authority considers that it should intervene, and it is appropriate for it to take steps to make sure that the child can protect itself against the father doing it again. So the question then is, at a very high level, are those facts, the authority recognising in the face of specific allegations a need to take steps to mitigate that risk? Could that be, that's the Statutory Act, could that be there's something more that indicates it's not just statutory powers to investigate and so on, it's a state of affairs where the authority itself recognises that it must do something to stop the child being harmed? If so, when we investigated the facts, could that be there's something more?
I think my answer to that is that if one looks at the wide number of circumstances which existed in these two cases, in Poole, in Mrs Justice Lambert's case, one's got really quite a wide field of different activities that should, or in many ways, many people's views, should have resulted in further response. What I respectfully submit is that something more means something other than not doing what, in retrospect, you should have done, given the somewhat egregious
That's
situation.
why I've looked at the facts of this case very specifically. It's the father, the child said, he's touching me, he's touching my breast. And the authorities say, yeah, we need to do something about that. We've got to look after this little child. We've got to make sure she's armed with the knowledge to stop it happening. And my question is, because this is an area where we haven't applied Poole yet, isn't that at this stage enough to say, well, we need to know the facts about that a bit more before we say that could never be the something more?
With respect, that is really saying that if the facts are bad enough, then there must be a duty.
No, that's not the answer. I've tied the facts not to the bad enough, but to the specific allegation and the response.
But effectively, if a particular case can come up with sufficient on the evidence, they will no doubt say there were signs, because by definition, of course, sadly, these cases are cases where claimants have usually been abused, and very often there might, in retrospect, have been signs, whether the sort that you're Lordship has postulated, or other signs. But something more we submit does not mean that you trawl through the minutiae and say, well, in this case, since we can't rule out the possibility of this, then we can't strike out the case altogether, which is what the learned friends effectively say. In fact, during the course of her submissions yesterday, the learned friend said, well, once the local authority gets involved, that's plainly not enough.
Well, it sounds if you'd adopted it says, Miss Campbell says, because it might sometimes happen, you can never strike out a case because you need to look at the facts. You are saying, well, because it's the exercise of statutory power and it's protection against harm caused by third parties, there's never going to be liability, even though there are no policy considerations, although you have to accept the possibility that it could happen. But
there might be
in the middle of this situation where we're still working our way towards what sort of thing in this context would be enough.
There might be some private arrangement by a social worker or some sort, or something outside the normal scheme, I suppose. I mean, I'm reluctant to make any concessions of this sort because I can foresee Lord Folks conceded that there might be an assumption of responsibility in these circumstances. But I'm not making any concessions, but it would be most unwise to rule out the possibility that on some egregious facts there might be an assumption of responsibility. Something perhaps where the social worker was acting outside the normal statutory scheme and gave some particular assurance. When I come to the police case, I'll give perhaps a parallel example.
So really where we are is you and Ms Campbell are a long way apart. She says, as she did at one point, as soon as the local authority gets involved, there's an assumption of responsibility. Whereas you're saying the scope for the assumption of responsibility is very narrowly restricted on the authorities. Yeah. Right. So, what else do you want to say on DFX?
I think that that's all I need to say. The analysis of the law by Mrs Justice Lambert is actually helpfully repeated in Mrs Justice Stacey's judgment. So although I absolutely endorse what Mrs Justice Lambert says, I don't think I need to take the court specifically to it because the court already has it. So now if I can come back to Poole after that excursion. Yeah. I mentioned yesterday that the legislative context was specifically set out. We get that at page 514. So that is the context in which the court was considering this question of whether a duty existed or not. During the course of submissions before the lower courts, and indeed I think somewhat yesterday, the question of whether there was a duty under the Housing Act came up for consideration, to which a friend answered, well, there isn't any duty under the Housing Act because of House Rules Authority. So in a sense, they decided to proceed under this particular route to try and establish a duty of care. And therefore, that's the context in which the court considered it. So it's a little inelegant for the learned friend to say, well, actually, this wasn't the right way to approach it. Notwithstanding the fact that that's the way it was pleaded, that's the way it was relied, and that was the basis on which the whole court considered the matter. So that's what we say about that. If there's any doubt about what the legislative context in which they were considering was, there it is.
Yes. Section 17.
Yes.
Not Section 22.
Not Section 22, because that didn't specifically arise.
Of course not. The child wasn't a copy.
No.
Children were not being looked after.
No. And I accept that's a potentially different aspect, although Your Lordship has my submissions on that, and we set them out full in our skeleton. But it's perfectly true that Section 22 doesn't specifically come under consideration by the court here. The passage at paragraph 28 is highlighted. This is at page 517 of the bundle. And this is now, I think, clear law. Like private individuals, public bodies did not generally owe a duty of care to confer benefits on individuals, for example, by protecting them from harm. And then gives the authorities, I'm intentionally drawing a distinction between causing harm, making things worse, and failing to confer a benefit, not making things better, rather than the more traditional distinction between acts and omissions. I mentioned yesterday that acts and omissions are sometimes considered not completely satisfactory as a division, partly because the former language better conveys the rationale of the distinction drawn in the authorities, and partly because the distinction between acts and omissions seems to be found difficult to apply. As in the case of private individuals, however, a duty to protect from harm or to confer some other benefit might arise in particular circumstances, as for example where the public body had created the source of danger or had assumed responsibility to protect the claimant from harm. This is an important paragraph because it summarises that there are rather limited circumstances in which there might be a duty. Dorset yacht, of course, taking the Borstal boys to the vicinity of the yachts on moored off Brownsea Island. Gorringe being the Highways Act case where they failed to put a sign which they might otherwise have put in. So a positive act. There's explaining that. And then he refers to Gorringe again at page 518. And a quote from Lord Hoffman we see at the bottom of the page.
That's in. That's again in Gorringe. Yes.
It's in Gorringe.
Lord Hoffman in 31 is in Sturgeon and Wise, is it? Yes.
Yes, it is. And he goes into the history of the law of tort, which Anne's was then reversed in Murphy. That's about duties of local authorities in respect to building regulations. And what he said in Sturgeon and Wise, if such a duty does not give rise to a private right to sue for breach, it would be unusual if it nevertheless gave rise to a duty of care at common law, which made the public authority liable to pay compensation for foreseeable loss caused by the duty not being performed. That's a useful passage, and I'm grateful to my Lord for reminding me of that passage, because it very much echoes what I was attempting to submit in answer to my Lord's questions about section 22.
Well, you said it was Sturgeon and Wise and Gorringe that we should be looking at.
Yes. And then we see 32, further clarification was provided by Gorringe in a speech with which other members of the appellate committee agreed. Lord Hoffman reiterated the importance of the distinction between causing harm and failing to protect from harm in the context of a highway authority's alleged duty of care to provide warning signs on the road. It's not sufficient that it might reasonably have foreseen that in the absence of such warnings some road users might injure themselves or others. Reasonable foreseeability of physical injury is the standard criteria for determining the duty of care owed by people who undertake an activity which carries a risk of injury to others, but it is insufficient to justify the imposition of liability on someone who simply does nothing, who neither creates the risk nor undertakes to do anything to avert it. That's the passage I was referring to by not doing something that may have cried out for action, but was not actually represented by.
But is the second half of the final sentence, nor undertakes to do anything to avert it, I mean, is that the equivalent of an assumption of responsibility in this slightly different context?
Well, what he's saying is it's insufficient to justify imposition on someone who simply does nothing, who neither creates the risk nor undertakes to do anything to avert it. The duty to avert it was said to be arise from the highway authorities' duty to repair the highway, and it was concluded there that you couldn't.
Well, but this is rather different, isn't it? Because the word undertake is suggests to me that what Lord Hoffman is referring to is somebody who says, well, I can see I haven't created this risk, but I am going to make it better.
Well, that's, my lady, why I referred to Stoughton and Wise, and we can go to that if necessary, where they had actually decided to do something, but they didn't get round to doing it.
Well, there's a difference between an uncommunicated decision and an undertaking. I mean, undertaking to me suggests a promise, or something equivalent to a promise.
Yes, well, I think I probably need to go to Gorringe if that's the interpretation that your ladyship's putting on what he said.
Well, no, I'm not. I'm just asking the question. The question I'm asking is Lord Hoffman in that passage adverting to the possibility that despite the fact you haven't created the risk, you might nonetheless do something which showed that you were taking a responsibility to do something about it.
Of course, that is, taking those words like that, I accept that there is an interpretation to that effect. But if one looks at the case overall, and of course assumption of responsibility is in a sense where the court has decided that you've assumed responsibility. And there may be a promise to do something which in some circumstances a court might decide was an assumption of responsibility. But if one looks at the facts of Gorringe and what the court was considering both in Gorringe and Stovin, I would respectfully submit that one doesn't get to the situation of saying that because a private authority said they're going to do something, that translates into there being a duty of care. And I go on to refer to what Lord Hoffman also emphasised, the difficulty of finding that a statutory duty or power generated a common duty of care, observing that it was, quote, difficult to imagine a case in which a common law duty can be founded simply upon the failure, however irrational, to provide some benefit which a public authority has a power or public law duty to provide.
That doesn't seem to impinge upon the point made about undertaking. I think we probably do need to look at Gorringe,
Very good.
actually, in case there's anything that elaborates upon this point that
Yes.
the lady has elaborated on. So,
Gorringe is
9, immediately after the effects, as it happens.
Yes, at page 215. The claimant's driving her car on a country road. Seeing a bus, she braked, the car skidded and hit the bus, and she was severely injured. The bus driver wasn't to blame. Some years prior to the accident, there had been a slow sign painted, but it had subsequently disappeared. The claimant brought proceedings against the defendant highway authority, contending the accident had been caused by the authority's failure to give her proper warning of the danger posed by the crest in the road, particularly its failure to provide a slow sign. And the court held, dismissing the appeal from the Court of Appeal, maintaining the highway under the Highways Act meant to put and keep the highway in repair, and that repair did not include the provision of information by means of street furniture or painted signs, that public law duties in section 39 of the Road Traffic Act, which are not in themselves enforceable by a private individual, did not give rise to a parallel duty of care at common law to take appropriate measures, including the painting of warning signs on roads.
Okay. We've got quite a lot of judgments here. Speeches, they probably were.
Indeed, and I don't want to take up too much time, but I have been invited to refer to it. Can I take the court to...
No, don't rush through it if it's important.
Well,
Where do we go first?
I think probably it's helpful to go to page 226, bottom of the page, in the passage which is, I hope, highlighted.
Yeah, so we're passing over Lord Steen and...
Yes, I think Lord Hoffman, after all, Lord Hoffman's dicta are the ones that we're looking at.
Yeah.
His judgment is generally
And I
considered.
think it's one of those cases in which, helpfully, everyone agrees with each other.
Yes.
In the same words.
No, no,
helpfully or
no,
not?
no. They all have a little paragraph at the end saying for these reasons and the reasons given by my.
They do, yes.
Whatever the formula is.
I think my ladyship's right. I don't think there was any distancing from what Lord Hoffman
Okay,
said.
so we can confidently focus on Lord
I
Hoffman.
mean, at least two other members of the court agreed with what he said, and I think.
Okay, all right.
That's probably enough.
Yes, that's why I said that.
Yes.
It is enough for the Court of 5. Yes.
So, paragraph 38. Does your lordship have that?
38.
My lords, I must make it clear this appears to concern any attempt to impose upon a local authority a common law duty based solely on the existence of a broad public law duty, not concerned with cases which public authorities have actually done acts or entered into relations or undertaken responsibilities which give rise to a common law duty of care. In such cases, the fact that a public authority acted pursuant to a statutory power does not necessarily negative the existence of a duty. And this is useful. A hospital trust provides medical treatment pursuant to the Public Law Duty 1977 Act. The existence of its common law duty is based simply upon its acceptance of a professional relationship with a patient no different from that which would be accepted by a doctor in private practice. The duty rests upon a solid orthodox common law foundation, and the question is not whether it is created by the statute, but whether the terms of the statute, for example, in requiring particular things to be done or conferring its discretion, are sufficient to exclude it. Thus, in Dorset Yacht, he refers to Dorset Yacht, and then Barrett and Enfield, the plaintiff claimed that when he was taken into care, the council assumed parental responsibilities over him, so came under a duty of care in respect of the way in which he was treated. And then Phelps, he refers to similarly in Phelps, the local education authority employed an educational psychologist. So those were the differences where there was, as it were, a duty where there would otherwise have been. Now that puts in context, we would submit what he meant. And then he concludes, my lords, in this case the council is not alleged to have done anything to give rise to a duty of care. The complaint is that he did nothing.
Where are you now?
The very part 444. The complaint is that he did nothing. Section 39 is the sole ground on which is alleged to have had a common law duty. In my opinion, the statute could not have created such a duty. The action was therefore fair.
You've got to, I mean, the problem in this case, when you read the whole of it quickly, they painted the stop warning 7 years ago, and then it had gone because there was roadworks. And 43 is key. So the reason for it appears to be that by painting the lines in the first place, the council had created an expectation that there would be lines to warn people.
Yes.
I thought that was a rather artificial expression. They didn't express the view. But he went on to say, where the authority conducts itself so as to create a reasonable expectation about the state of the highway, it will be under a duty. So there are circumstances where the way it goes about its task can create the circumstances capable of giving rise to private law duty of care.
Yeah, what he says is it will be under a duty to ensure it does not thereby create a trap for the careful motorist. So I would submit that, although this isn't strictly speaking relevant to this particular case, we have going some to establish a duty whereby there was a trap as a result of the non-exercise.
No, but the words, we mustn't get seduced by words. What he's saying is conduct can amount to the legal circumstances to which the court will attach a private law duty of care, and that's what's said to be the case here. The conduct is different because it's not painting lines on the road. It's conduct in promising to do keeping safe work or providing accommodation because there's a risk to the child on certain days. That's would be the parallel.
I've just looked at paragraph 17.
Mm.
Paragraph 17 is a summary of the submissions of Mr. Wingate Shaw. It seems to me. So it's not Lord Hoffman's actual reasoning. And it's been quoted by Lord Reed as though...
Yes, well, I'm very grateful for that. That's,
it is. But I think it's pretty clear that even in his own reasoning, Lord Hoffman is envisaging that a duty could arise where you have an express or implied undertaking to do something. So he uses the word undertaken responsibility, phrase undertaken responsibility.
It's 38.
Paragraph 38. He also, in his analysis of Phelps in paragraph 40, refers to an implied undertaking by the educational psychologist. And then, as my Lord Justice Lewis has pointed out, there's the reference in paragraph 43 to conduct, which might create a reasonable expectation about the state of the highway. So, so I'd suggest to you that Lord Hoffman is not excluding the possibility that an authority which does nothing might nonetheless be liable because in some way it's suggested expressly or implication that it might be going to do something.
that may be so, although Stogan and Wise is perhaps not wholly, it doesn't support that very strongly.
Well, should we come back to Stogan and Wise? Just take stock of where we are with Gorringe.
Yeah.
Passage in 17 is, as Milady points out, strictly speaking, from Mr. Wingate Saul's submissions. I think, Lord Reed was endorsing. Lord Hoffman was endorsing it, I think. But what he says in 38 is that this case is not about cases in which the public authorities have actually done acts or anything in relationships or undertaken responsibilities which give rise to a common law duty of care. And he says the fact in such cases, the fact that the public authority acted under a statutory power doesn't necessarily negative the existence of a duty. So, how does, and then passage 43 to which the law referred. So how do you sum up your submissions on Gorringe in support of your case?
Well, obviously I rely on the way they were interpreted by Lord Reed in Poole, because that's obviously more relevant to these particular facts. But he also relies on Stovin.
Yes, do you want to go back to Stovin?
Can I just briefly do that?
Okay.
Which we can find at tab 21. The facts are quite important, so I can briefly read them out if I...
Hang on, 21 did you say?
It's at tab 21, page 731.
Thank you. Yeah.
The plaintiff was riding a motorcycle along a road, collided with a motor vehicle driven by the defendant. Out of a junction, the plaintiff was seriously injured. The junction was not a busy one, but it was known by the County Council as the highway authority to be dangerous because the road user's view was restricted by a bank on adjoining land. Accidents had occurred there on at least 3 previous occasions. In January 1988, after a site meeting, a divisional surveyor of the council accepted that a visibility problem existed and recommended removal of part of the bank. The council accepted the recommendation, provided the owner of the land agreed. The owner made no response to the council's proposal before the plaintiff's accident, notwithstanding a further site meeting where the council and the owner's representatives were present. Held, Lord Slynn and Lord Nichols dissenting, that the question of whether the existence of a statutory power gave rise to a common law duty required an examination of the policy of the statute, that the absence of a statutory duty would normally exclude the existence of the common law duty of care, and that accordingly the minimum preconditions for basing a duty of care on a statutory power were first, that it would be irrational not to have exercised the power, so there was in effect a public law duty to act, and secondly there are exceptional grounds for holding that the policy of the statute required compensation to be paid to persons who suffered loss because the power was not exercised. And of course we do rely on that in general terms, and this much of X has always been clearly the law, which is that it is clear that the relevant social services legislation does not give rise to a claim for breach of statutory duty, and that is the same with the Highways Act in this context. And there is a passage 737 under the heading liability for omissions. The starting point is that the council did not create the source of the danger. Letter H. This may help, I think, in answer to the point. The council does not create the source of it. This is not a case of a highway authority carrying out roadworks carelessly and thereby creating hazard. Maybe that's what's meant by undertaking some actual work. In the present case, the council cannot be liable unless it was under a duty requiring it to act. If the plaintiff is to succeed, the council must have owed him a duty to exercise its powers regarding a danger known to it but not created by it. Well, that's a helpful passage, we submit. The distinction between liability for acts and liability for omissions is well known. It's not free from controversy. In some cases, the distinction is not clear-cut. The categorization may depend on how broadly one looks when deciding whether the omission is a pure omission or is part of a larger course of activity set in motion by the defendant, and then failing to apply the handbrake is the classic illustration of the latter, Thus, the omission is the element which makes the activity negligent. Dorset Yacht being an instance where the distinction is not easy to apply. Despite the difficulties, the distinction is fundamentally sound in this area of law. The distinction is based on a recognition that it is one matter to require a person to take care if he embarks on a course of conduct which may harm others. He must take care not to create a risk of danger. It is another matter to require a person who is doing nothing to take positive action to protect others from harm for which he was not responsible, and to hold him liable in damages if he fails to do so. The law has long recognised that liability can arise more readily in the first situation than the second. And I think maybe the undertaking is if you are actually going to do some roadworks in an attempt to solve a particular problem and you do them badly, that's rather different. You're actually doing something, and maybe that's what it means.
I don't want to be unhelpful, but you will regard it as unhelpful. The problem is when you go to 71 and 751 and 752, in this case, Lord Hoffman did have a heading acts and omissions,
Yes.
and he said the judge made no express mention of the fact the complaint against the council was not about anything which it had done, but about its omission to make it safe. But unfortunately, from your viewpoint, when you get to D on the next page, there may be a duty to act if one has undertaken to do so or induced a person to rely upon when doing so. And that takes us straight back to the undertaking or leading someone to believe, which is what Miss Cumberland is, I think, relying on really. That's the problem. There's something in this case for everyone to do.
Yes.
But also, if we go back to paragraph 38 of Stone and Wise, which is quoted by Lord Reed. Sorry, is it 38? Let me just get it right.
I think it was 38, wasn't it?
See, if they did nothing to investigate and people are ringing up and they said, well, we're not doing anything, and then if they do something, if they say, yeah, we will investigate, we'll look at this, we'll do training, one wonders then, we're just at the moment in a grey area.
Well, if they actually
The quotation is from Stephen and Wise by Lord Reed is from 959, is, he said 952. No, 952 in the report, so it's later on. 760 in the bundle.
But the passages that are cited by Lord Reed in paragraph 32 of his judgment distinguish between undertaking an activity and undertaking to do something, or undertaking responsibilities, and those are two different things, aren't they? If you undertake an activity, you do something. If you undertake to do something, you're not doing it, you're promising to do it. Would you accept that?
Yes, I mean, undertaking, of course, has different meanings in different contexts, whether it's a formal undertaking which can give rise to an application of a contempt in the court, or whether it's a statutory undertaker. The slight problem about you use the word undertaking is a statutory highway authority is a statutory undertaker. I'm not sure that's the
no, I don't think that's the answer.
I don't think it is the answer.
I mean, maybe we need to look further into what Lord Hoffman says, but I'm not saying we do that now. But
No.
D at 944, Lord Hoffman does say there may be duties to act if one has undertaken to do so. I don't really worry about induced, probably. So the reference to undertaking, that must mean a promise or something of that nature, mustn't it?
Well, I think that's where, when I get to Michael, we'll see that the police undertook to look after an informant. And that would be an undertaking, I accept. And that's an example of an assumption of responsibility, where there's something outside the normal position with the police, where you've said, I'm going to look after you, like putting someone in the witness protection program, something of that sort. There is an undertaking there.
But the point we're putting to you is quite a simple one. It's that it seems to us from these passages that Lord Hoffman was recognising that there was no responsibility to do something unless you had promised or undertaken to do it, in which case there might be.
And the fact that there was a breach, that there was a statutory duty, doesn't necessarily mean there wasn't a duty arising out of the undertaking. That's what he says in Gorin.
So, I mean, either you accept that or you don't, but I mean, we're not sort of making very much progress. So if you don't accept it, just tell us. And if you do accept it, tell us. But let's move on.
Yes, well, I think the answer is I don't accept it.
You don't accept it. All right, thank you.
So right.
My submission is that assumption of responsibility has to be on the authorities narrowly construed, and that's consistent with what Lord Reed says in Poole.
So just so we're clear what you're not accepting. You're not accepting that undertaking to do something may give rise to a duty of care.
Well,
which is what Lord Hoffman...
Well, I think what you're really saying is where the undertaking amounts to no more than the actual exercise of the power, that in itself isn't enough.
No.
The use of undertaking is something over and above the mere exercise of the statute. I think
that is exactly what I'm saying.
Thank you, yes.
We don't say undertaking by itself.
Right. Well,
I'm sorry, I thought that was clear.
Yes, that's a helpful intervention.
Oh,
They just pointed out. Would you like... So, why don't, instead of the three of us firing things at you, why don't you just take a moment and just say what, in light of our observations, what your submission is?
Our submission is, and I think it's contained in our skeleton, is that simply undertaking to do no more than you are obliged to do under the statute does not give rise to a duty of care. Something more is required. Because the Supreme Court has held that the mere non-exercise of a power does not, if it's in the course of a statutory scheme, give rise to a duty of care.
So there has to be something more than an undertaking in order to make it an assumption of responsibility.
But if I promise to do something which I'm obliged to do anyway, it isn't something more.
The exercise of a statutory power or the performance of a statutory duty cannot be the thing that amounts to an undertaking.
No.
Because the cases say it doesn't. It's something in addition to the mere exercise of a duty or function, is what I think.
Yeah, that's exactly right.
Yeah.
The lady's shaking her head. I don't know whether I can clarify.
No, I don't think so. It's probably my fault. I think we've exhausted this topic. Thank you.
So, having been via the highway,
And the byways.
and the byways,
Are we...
And the unmaintained
Are we...
side road.
we've avoided the dangers.
pitfalls? Potholes?
Plenty of warnings, yeah.
Are we...
We're going back to.
We're going to come to the police case, I think.
We are. And I haven't.
And the emergence of assumption of responsibility.
Yes. I think I can do that.
I'm not going to hold you to the short adjournment for your completion. If you're worried about that, we're quite clearly, despite our attempted reticence, we've obviously taken longer than you hoped.
Well, I've attempted, although clearly unsuccessfully as far as my lady's concerned, to try and engage with the questions that you posed.
You have engaged all of our...
I was looking at Poole, and I think, if I may, I'll finish looking at Poole before I move on briefly to the other authorities, because this is where, as it were, the diversion via the Highways Act came. And I was looking at paragraph 33 and Lord Hoffman's at paragraph 38. We've now moved, as it were, to the source material there. 34, it took time for the significance of Stogan and Gorringe to be fully appreciated. Confusion also persisted concerning the effect of Caparo until the clarification was provided in Michael and Robinson. And Michael's the only police case I'm really going to spend any time on. The long shadow cast by Anne's, the misunderstanding inquiry have to be borne in mind when considering the reasoning of the decisions concerned with the liabilities of public authority in negligence which date from the intervening period. Although the decisions are generally consistent with the principles explained in Gorridge and later cases and can be rationalised on that basis, their reasoning has in some cases and to varying degrees been superseded by those later developments. Can I move on then to to page 528, where he draws together Lord Reed, the jurisprudence, and says it follows that public authorities may owe a duty of care in circumstances where the principles applicable to private individuals would impose such a duty, unless such a duty would be inconsistent with and is therefore excluded by the legislation from which their powers or duties are derived. 2, that public authorities do not owe a duty of care at common law merely because they have statutory powers or duties, even if by exercising their statutory functions they could prevent a person from suffering harm. And 3, that public authorities can come under a common law duty to protect from harm in circumstances where the principles applicable to private individuals or bodies would impose such a duty, as, for example, where the authority has created the source of danger or has assumed a responsibility to protect the claimant from harm, unless the imposition of such a duty would be inconsistent with the relevant legislation. And it's then that he comes on to consider assumption of responsibility, which was much focused on by the learned friend. And I don't think I need to go through all of this passage because we can see the development via Headley Byrne, very different, but to do with economic loss. And in fact, in X and Bedford, it was argued that actually assumption of responsibility might only apply to economic loss, although the House of Lords decided that in fact went, potentially at least, went further than that, so that's no longer the case. And then he says at 68, since Headley Byrne, the principle has been applied in a variety of situations in which the defendant provided information or advice to the claimant with an undertaking that reasonable care would be taken as to its reliability. So that's the undertaking use in that context there. For example, in Smith and Bush, undertook the performance of some task or service for the claimant with an undertaking that reasonable care would be taken. And in Henderson and Merritt, and in Spring and Guardian, there's a quote from Lord Gough. Spring and Guardian was the reference case. And that approach is reflected in the case previously discussed. In X, the social workers were held not to have assumed responsibility towards the claimants in their child abuse cases on the basis they were not providing their professional services to the claimants. It was not reasonably foreseeable they would rely on the reports. But said contra, where the education authority was concerned, then he refers to Barrett and Phelps. And it's convenient, he says at paragraph 70 at this point, to consider a submission advanced on behalf of the Council in the present case, said to be supported by some recent decisions of the Court of Appeal, in particular Lord Justice Dyson, as he then was in Rowley, where it was held the Secretary of State, in carrying out his statutory duty to make an assessment of child support maintenance, did not assume responsibility towards the parent. Dyson focused, or the child, on the requirement that the responsibility must be voluntarily accepted or undertaken. Lord Devlin put in Headley Byrne, it was not merely by the Secretary of State's performance of his statutory duty under the legislation. So that, of course, one does come back to the Headley Byrne, which is somebody says, in effect, or the court concludes they have voluntarily assumed a responsibility. A very different situation to where you have social workers doing their best to do their job in accordance with the statutory scheme. And then the decision of X. I don't think I need to take to that passage because I'm going to take you briefly to X.
Okay. I thought you quite liked the passage at C and D when I read it now. The public authority will not be held to assume a common law duty merely by doing what the statute requires.
Well, indeed, that's why I was going to take you to that case. I mean, because that's indeed the passage upon which we place considerable reliance.
Yeah, and you like that, and you like the fact that the Supreme Court approved it, I thought.
Your Lordship has my point.
Yeah.
And then, furthermore, we say the correctness of these decisions is not in question, but the dicta should never be understood as meaning the assumption of responsibility can never arise, and that was a point that was made by my learned friend. Dyson based his reasoning on Rowley. I think the rest of the decision has been well and truly gone over. I'm not sure that I need to say any more. Our submissions are contained in in our skeleton. There is a lengthy analysis, but can I deal with the one point which I know troubles the court, or at least some members of the court, which is the point which we find at paragraph 90. What he has done is considered all the leading authorities and come to the conclusion that there is no duty of care. He says at 89, the existence of an assumption of responsibility can highly dependent on the facts of the particular case, where there appears to be a real possibility that such a case may be made out. The court will not decide otherwise on the strikeout application. In the circumstances which I have described, they do not, particularly as a claim here, set out any basis on which an assumption of responsibility might be established at trial. And then he says, and this is the Lady Justice King contribution, any uncertainty as to whether the case is one which can be properly struck out is eliminated by the further difficulties. Now the question is how you read that in terms of how it affects the significance of this decision. We say that's an additional reason, of course, but it's very much not central to the case. The central case is the analysis that he makes of what the law is. And I think, with respect to say that because there was another reason why the claim was doomed to fail, you can therefore ignore everything he says. Well, I'm putting that argument a bit high, but that's the way it seems to be said. Cannot be right. I'm reinforced in that submission by one looks at the very conclusion of the case, at paragraph 91. The particulars of claim in these proceedings do not disclose any recognisable basis for cause of action. That's his conclusion. The complaint is that the council or its employees failed to fulfil a common law duty of care to protect the claimants from harm inflicted by their neighbours by exercising certain statutory powers. The relevant provisions do not themselves create a cause of action. Reliance is placed on an assumption of responsibility arising from the relationship between the claimants and the council or its employees, but there is nothing to suggest that those relationships possess the necessary characteristics for an assumption of responsibility to arise. And then the next paragraph says that furthermore, in colloquial terms and another reason, it is clear that the alleged breach of duty, namely a failure to remove from the care of the mother, has no possible basis.
Sorry,
So,
the next paragraph or next sentence?
Next sentence. Furthermore, it is clear that the alleged breach of duty, namely a failure to remove the claimants from the care of the mother, has no possible basis. So, yes, it's a furthermore factor, but it doesn't undermine or take away the force we submit of the analysis as a whole.
Yes, now,
So now
you're going to go, I think you said to Hounslow, are you?
I can go.
And Michael.
Those are the two main cases I want to take you to. Perhaps I can go to Michael now, if I may, which is tab 14. So this was a decision of the Supreme Court, a 7-judge court. The victim made an emergency call on her mobile phone to the police from her home. And essentially there was a mess up because it was obviously urgent. It was wrongly graded by the police. And sadly, by the time the police responded, it was too late. I think that's not an unfair summary of it. Held, the majority, Baroness Hale and Lord Kerr dissenting, not an uncommon situation in these cases, that the duty of the police for the preservation of the peace was owed to members of the public at large and did not involve the kind of close or special relationship necessary for the imposition of a private law duty of care, that it did not follow from the setting up of a protective system from public resources, that if it failed to achieve its purpose through organisational defects or fault on the part of an individual, the public at large should bear the additional burden of compensating a victim for harm caused by the actions of a third party. Of course, the third party being exactly our case, for whose behaviour the state was not responsible. That to impose such a duty which could not be rationally confined would be contrary to the ordinary principles of common law. And then he deals with another point I don't think I need to trouble you with. Can I take the court to page 465? I can go very briefly through this, but it's a very convenient summary of the way the law developed through Osmond, which caused some consternation. Then Brooks, and your Lordship may remember I mentioned that yesterday, that's the friend of the Stephen Lawrence, which followed the Hill case, but nonetheless determined that there was no duty of care in terms of investigation. But importantly, paragraph 47, Lord Stane, with whom Lord Roger and Lord Brown said the principle in Hill should be reformulated in terms of absence of duty rather than blanket of immunity. Immunity became an unfashionable term, particularly after the European Court of Human Rights. He noted that it was conceded by the police that cases of assumption of responsibility under what he described as the extended Headley-Byrne doctrine fall outside the principle in the Hill case. So I draw the court's attention to that because here there is the possibility of assumption of responsibility against a public authority. And the question is, in what circumstances might it exist? Can I take the court on to page 469? But paragraph 67, picking up what Lord Gough said, the Headley-Byrne case was widely regarded as a case on liability and damages for negligent misstatement and liability and negligence for economic loss, which it was, but it was important not to lose sight of the underlying wider principle. The underlying principle rested on an assumption of responsibility by the defendant towards the plaintiff, coupled with reliance by the plaintiff on the exercise by the defendant of due skill and care. The principle that a duty of care could arise in that way was not limited to a case concerned with the giving of information and advice, but could include the performance of other services. At paragraph 69, there is reference to an informer versus the chief constable. Provides an example of a duty of care arising from an assumption of responsibility coupled with reliance upon the claimant. The claimant contacted the police regarding the activities of a business associate. He was introduced to 2 police contact handlers. He agreed to act as an informant under the police instructions, and he later signed a set of instructions prepared by the police. At the outset, they explained the steps which they would take to protect his identity and gave him assurances that they would treat his safety and that of his family as a priority. As the investigation developed, the claimant himself became a suspect. A restraint order was placed him under POCA, prohibiting him from disposing of his assets, but the Crown Prosecution Service eventually decided not to prosecute him. The restraint order was discharged. He sued the police, alleging they owed him a duty of care to protect his economic interests. The police conceded that they owed a duty of care to protect his physical well-being and that of his family. They had assured him they would do so, and he had acted on the faith of their assurance. But they gave him no assurances they would protect his economic interests. And the Court of Appeal upheld the judge's decision that they owed him no such duty, which potentially conflict with their responsibility to the public for the investigation of crime and the proceeds of sale. Proceeds of crime, sorry. So what I get from that is that there are circumstances, notwithstanding the general absence of a duty of care, where the police can be said to have assumed responsibility. But it does involve a specific and rather unusual assurance, because generally speaking, the duty is not susceptible of there being a duty of care. There was a reference to Kenton Griffiths, which my learned friend referred to yesterday. And there's one important fact about Kenton Griffiths, which is the reliance, which is paragraph 81, page 472. That was the patient who suffered a respiratory arrest, which would have been prevented if the ambulance had arrived in a reasonable time. The problem was that there's no duty on part of an ambulance service to arrive at any particular time, but there was an alternative means of transport. They effectively said in shorthand, we're coming. So she didn't use the alternative, they didn't come, and that was causative. So there was a reliance and there was an alternative. But simply by not turning up, or as in capital counties, not getting lost on the lanes if you're a fire brigade, that doesn't of itself create a duty owed by the fire brigade. You have to make something worse, or do something, which is what happened in capital and counties where they turned off the sprinklers. 475, there's a useful reiteration at paragraph 97 by Lord Toulson of the classic position whereby the English law does not as general rule impose liability on a defendant for injury or damage to the person or property caused by the conduct of a third party. Of course, that's very much echoed by in Poole. The fundamental reason is that common law does not generally impose liability for pure omissions. It's one thing to require a person who embarks on action which may harm others to exercise care. It's another matter to hold a person liable in damages for failing to prevent harm caused by someone else. That's precisely the situation. The rule is not absolute. There are two recognised types of situation where they may impose, and then one is where there's control. That's the Dorset yacht being a classic example. And then paragraph 100, the second general exception assumes a positive responsibility to safeguard sea under the Headley Burn, as explained by Lord Gough in Spring Guardian. And it also has reference to Mitchell.
Right, so relation identifies a series of relationships.
Yes, none of which we submit could apply in this particular case.
So this is not exhaustive.
Why wouldn't it apply?
It's not exhaustive, no, your lawyer is quite right.
Why wouldn't it apply to social worker and client once there'd been a relationship established?
Well, that's the learned friend's submission, which is once the social worker becomes involved and there is an assumption of responsibility. And we submit
why could you say it couldn't apply to social worker-client relationship?
My answer is that it will not generally apply because of the fact that there is no duty owed by social workers doing their statutory, exercising their statutory powers. It's clear from Poole that there could be situations in which they're arisen, but just as there can be exceptionally, as is referred to in the police case here, but he needs something more, something exceptional.
Well, let's just look at 100 and see what it is. If in section paragraph 100 here, in Lord Toulson's judgment in Michael,
yeah,
which affects it either way. Positive responsibility is where D assumes a positive responsibility to protect, to safeguard C. And then there's a series of relationships: contract, fiduciary, employer, employee, school and pupil, health professional, and patient.
Yes, of course.
And list not exhaustive. So why?
Well, there are some distinctions because, of course, Headley Burn and Spring Guardian are not concerned with a statutory bodies at all. They're not. These are akin to contract, or there's a private duty, so that the court, in deciding there's an assumed responsibility, isn't impeded by the general principle. There is no duty of care arising from the exercise of a power. So,
but see the first sentence of paragraph 101 where Lord Toulson recognises that.
so I didn't quite hear what your ladyship said.
I'm so sorry. See the first sentence of paragraph 101 in which Lord Toulson recognises that point.
Yes, exactly right. These general principles have been worked out for the most part in cases involving private litigants, but they are equally applicable where D is a public body, and then refers to
Mitchell. Well, let's just read Mitchell.
Yeah.
Okay.
And then in Mitchell,
what do we make of the last part of 100? By the way, we glossed over that. Lord Toulson doesn't seem to like the phrase, didn't seem to like the phrase assumption of responsibility.
Well, I think what he's saying is that there has sometimes been a tendency for the courts to use the expression when in truth it's been imposed by the court, and it should not be expanded artificially, because the fact that somebody says I assume responsibility, they're not likely to say that, of course, but it's a term of art. It means the courts have decided the particular circumstances are such that it is appropriate for the court to conclude that there has been an assumption of responsibility.
Yes. Well, we've been, yes.
So it's a legal conclusion
Yes.
drawn from the fact,
Exactly.
appropriate fact.
And it's a term of art, not necessarily a totally satisfactory term of art, but it's come to mean what Lord Tilson describes, and it's now part of the jurisprudence.
The problem
But it is
in
the
these
exception.
cases is that there's two halves to each of them. The first half begins by saying if it's the exercise of a statutory function, power or duty, generally you're not liable. But there may be exceptions, blah, 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 blah. I think, well, heavens above, we don't know what the exceptions are until we've looked at the facts. Then you read Michael and you think, oh, there we are, you don't have statutory responsibility unless it's a settled relationship. And that relationship isn't closed. And you think, well, what's the difference between a school and a pupil and a social worker and a little 4-year-old that they try to make sure isn't harmed by the father? And it depends. I mean, it's as if you're reading one bit, the first bit, Miss Gumbel is reading the second bit, and I'm sitting here thinking, well, how do we decide? And is it too early to decide yet? But you say, no, we must screw our courage to the sticking place, and we'll not fail, and we'll not get to the second part. We'll say this really is in the first part. But that's the problem with these cases, isn't it?
Well, it's a problem, and it's why they featured so often in the higher courts, and why different, as I began my submission, different tests have been adopted from time to time as to where the dividing line is to be drawn. I don't pretend it's easy, but for a moment.
No.
And in a sense, for example, Phelps went the other way in the Court of Appeal. The Court of Appeal concluded that actually the duty owed by the educational psychologist was a duty owed to the educational authority that employed her.
Wouldn't it be better to have a set of cases, 3 or 4 cases with different sets of facts? We've only got DFX, which doesn't cover direct involvement, direct work, because it says it doesn't cover it, and didn't have accommodation duties involved as well. And isn't it just a bit too early to say, given these tensions between the first half and the second half of the judgment, that we can be well, we can't be sure now, can we, that this wouldn't be the case?
Well, there of course there are historic facts of X and Bedfordshire which are recorded. I think the idea of listing these 2 cases together was that they covered a reasonable span. As I conceded at the outset, there will always be variations, and of course we have the facts of Poole itself. So, with great respect, I would say you had a reasonable.
Good enough, yeah, you think? Okay.
Enough
All
right. To make draw some conclusions.
So, have we finished with Michael?
No, not quite.
So, have we finished paragraph 100 and 101?
Yes. I think your lordship had read that paragraph, so I don't need to proceed with that. 479. There is paragraph 113. There having been reference to other cases, besides the provision of such services are not peculiarly governmental. It's a feature of our system of government that many areas of life are subject to forms of state-controlled licensing, regulation, inspection, intervention, and assistance, aimed at protecting the general public from physical or economic harm, licensing of firearms, regulation of financial services, inspection, and so forth. You can't compile a list exhaustively. It does not follow from the setting up of a protective system from public resources that it fails to achieve its purpose through organisational defects or fault on the part of an individual. The public, if it does fail, the public at large should bear the additional burden of compensating a victim for harm caused by the actions of a third party. This is a different way of describing why the courts, it may not be policy, one has to be a bit nervous about using that expression followed here, but it is explaining why should the public pay if this is what the system of social work, for example, we would say, is set up to do. The refusal of the courts to impose a private law duty on the police to exercise reasonable care to safeguard victims or potential victims of crime, except in cases where there has been a representation and reliance, does not involve giving special treatment to the police. It's consistent with the way in which the common law is applied to other authorities vested with powers or duties as a matter of public law for the protection of the public. And then the Wang Kwang Yu case, Davison, Radcliffe, Murphy, Stovin and Gorringe, all those cases. So that to return to the point put to me, the egregious point by Lord Justice Lewis, you could equally say with the police, well, why on earth did they mishandle this particular inquiry? And there's a case called Smith in Sussex, which comes under the Van Colley case, where the police had plainly acted inappropriately. They'd not done what they ought to have done. There was no dispute on the facts, notwithstanding that absence of a duty of care, or whether one calls it policy reasons, or because there is a reluctance on the part
The
of
consequences inform the situations in which a duty is imposed, is the proper way to put it now.
Exactly.
Of course, there is the passage, in 115, the qualification, except in cases where there has been a representation and reliance.
Yes. That has to be seen in the light of the cases that have so far been established as having a reliance. I mean, we haven't yet had a case where a claimant has, as it were, won a case entirely on the basis of a social worker's representation. Otherwise, both Belinda Friend and I would have either referred to it, not fought the case.
Yes, reliance is quite an odd thing to talk about in the case of a small child, isn't it?
It is, it absolutely is. It's not, whereas in Headley Burn one can see that reliance is particularly relevant. I think Belinda Friend sought to say that with a small child it's an imputed reliance or implied reliance or tacit reliance or whatever it might be, because he wouldn't expect them to rely, although I suppose there might be in some circumstances where it could be said there was some reliance, but
Well, they will be with older children.
there might be with older children.
Might be.
But what's your position about that? Will you submit that in the case of a baby, the law will imply reliance, or are you saying a baby can't rely and therefore a claim in relation to a baby couldn't succeed?
Well, I'm not sure that that reliance is really a terribly helpful concept in
No,
this field
well,
generally.
for my part, I think there's some force in that, as they say. It did feature quite a lot in Miss Gumbel's submission. So, do you think we should be worried about reliance or not?
I think that one of the reasons that courts have, on rare occasions, decided that there was an assumption of responsibility is because there was reliance. Lord Reed has postulated the possibility that in a social work context there might be an assumption of responsibility. Whether a reliance is crucial to that or not will depend on the facts, but I entirely accept that a small child wouldn't normally be said to be reliant in the way that somebody who's taking financial advice has.
I mean, we're dealing with an area of local authority responsibility, children, and of course the same would apply to incapacitated adults, where it's quite difficult to think that much would be pinned on actual reliance.
Well, in general terms, one could say that we all rely on public authorities in general terms to do what we want them, expect them to do. We know from authorities that there is no doctrine of general reliance. So occasionally people have tried to sue public authorities on the basis that we all rely on public authorities to do their bit.
Yeah.
That is clearly not the law. So there has to be something more. We come back to that elusive and not wholly satisfactory expression. And so there's got to be something about the assumption of responsibility, that of itself not a perfect expression, which takes it outside what local authorities do.
I mean, if there was a case of a child, let's take a case where you would accept that there could be a duty, a small baby taken into care and placed with foster parents and sustained injuries, so it's that sort of situation. The fact that you couldn't demonstrate any reliance would surely not be relevant to the question of establishment of a duty.
Well, I think in fact there would be a duty of care, and the claimants wouldn't need to rely on assumption of responsibility, because there would be a duty. The court would simply say that there was a duty having regard, whether it's called assumption of responsibility. I suppose it could be looked at assumption of responsibility. They've assumed parental responsibility, in fact, on that particular case by taking someone into care, as we get from Barrett.
But once you accept that the words assumption of responsibility really mean the legal conditions which give rise to a private law liability, you can see in economic context with adults, if they don't rely on what the bank manager says, well, why should you make the bank manager liable? But when you're looking for the sorts of conditions that generate a private law duty in respect of small children being abused, it becomes meaningless to talk about reliance, because reliance can't be the sort of thing that the law was looking at to attach liability, because reliance just can't arise in that context. Therefore, you're looking at things other than reliance.
I mean, there was reliance clearly in the informer case that I referred the court to there by the informer himself.
That's a good example. If they said, oh, we look after you, mate, and the guy said, right, I don't trust the police, I'm not going to believe a word they say, and I'll go off and do my own thing, that might have been different. And there it may be relevant to look at the statement made and the reaction of the person to whom it's made, because those might be relevant to the conditions under which the court will say objectively liability should be imposed. But when you come to small children, it's very difficult to see how the concept of reliance, a person responding intelligently to an undertaking, has any meaning, really. It can't be something that the law fixes on as one of the objective conditions giving rise to liability, because it's something that has no meaning in that context. That's why reliance doesn't seem...
I'm not sure, I think I can see.
I think you agree
it
with
helps
it,
very much
yeah.
in this analysis. We haven't got any further explanation from Lord Reed of the circumstances in which an assumption of responsibility might arise.
No. Well, that's rather my lord's point.
I know it's his point, but the fact that he doesn't rule out the possibility does not mean that, as it were, it's easy to find that there was one. So what one has to do, with respect, is to look at other rather rare circumstances in which there has been an assumption of responsibility. None of the analogies are perfect, I accept, but the fact that on the facts of these cases below, none of the judges thought there was an assumption of responsibility. It was no doubt fully argued by counsel in this case, and there wasn't one in pool, is a good indication that it's going to be a very rare bird.
But the other problem is that a lot of Mrs. Justice Lambert's reasoning, probably I'm afraid to say because of the way Miss Gumbel put the case, was that there couldn't have been reliance by the claimants on these reports. And I think it may be, from the submissions that Miss Gumbel made, that she has assumed that there has to be reliance either by the referrers or by the children or by someone. But if that goes, I wonder how reliable it would be for this court to rely on DFX as being the proper analysis, and unless the facts were different, or unless we were convinced that Mrs. Justice Lambert was wrong, we might be more persuaded that she's arguably wrong because she's focused on reliance when it doesn't arise.
Yes,
Sorry, I haven't put that clearly, but...
Well, I think I understand what you're saying, is in a sense, if reliance is a bit of a red herring, and if that was part of her decision...
by it, it wouldn't be right for this court to rely on DFX and say, in effect, this is an appeal against DFX, and DFX was right, because she's been led down the garden path of reliance.
Yes, in all the cases that are brought before the courts, there are always alleged to be shortcomings on the part of the local authority, things that have been missed or should have been regarded to, and different actions brought about. The corollary of this argument, and the argument that the Lordship's put to me, is if we can't have reliance as part of it, is there any reason that anything else shouldn't be an assumption of responsibility? What we say is the proper analysis of Lord Reed's speech is that he's essentially saying there is no duty, but he's saying never say never, because I accept the fact that there may be circumstances where there is assumption of responsibility. But what I submit does come from...
so you're saying that is what he's saying?
That is...
He's really saying never say never.
Yes. And that's what...
never.
That's what you'd expect with respect a judge to say. That's what, for example, the judges used to say about the police when they said, is there immunity or not? They say, well, We never say there could not be a duty, but the broad position is there is no duty. And then eventually an odd situation comes up, like an informer, or there's another case called Swinney, where they decide there is a duty. But the fact that he doesn't instance it perhaps shows that it's difficult to think of circumstances. Otherwise, perhaps he might have said there would be a duty, for example, if, but he was perhaps wise not to. But the general tone of his judgment clearly must be, and of course all of the others agreed with him, was that it'll be very rare and he's just not ruling out the possibility. But this, in a sense, sad though it is, these cases are pretty classic cases. There's nothing particularly unusual about them. We submit a sad conclusion, though that is to reach, or conclusion about these cases that come to court. Can I look at page 484, which I think is relevant to this question? This is at page 1, paragraph 138. Where the issue 3, just below letter F, is discussed. Should the police be held to assumed responsibility to take reasonable care for Mr. Michael's safety? So this is the pertinent question. Sir Bowen submitted that it was said by the Gwent call handler who received the 999 call was arguably sufficient to give rise to an assumption of responsibility on the Headley-Byrne principle, as amplified by Spring and Guardian. I agree with the Court of Appeal, the argument is not tenable. The only assurance which the call handler gave to Miss Michael was that she would pass on the call to the South Wales Police. She gave no promise how quickly they would respond. She told Miss Michael that they would want to call her back and asked her to keep her phone free, but this did not amount to advising or instructing her to remain in her house, as was suggested. Miss Michael's call was made on her mobile phone, nor did the call handler's inquiry whether Miss Michael could lock the house amount to advising or instructing her to remain there. The case is very different from Kent and Griffiths, where the misleading assurances were given. So that was the decision in Michael, which I submit is helpful to us, and of course it was referred to and endorsed very much by Lord Reed in Poole. May I now briefly go to X and Y and Hounslow, which is at tab 25. This was a case which came before this court, the Master of the Rolls, Lord Justice Tuttle and Lord Justice Goldring. And what happened was that the claimant's husband and wife lived in a council-owned block of flats. With
the same representation, I see.
Yes, your daughter has
once again
carefully observed that, yes. I suspect some of the same arguments might have been deployed too.
Yeah.
But in this case, just one social worker, this is important, T, gave advice and assistance to the claimants in managing their lives, visiting them regularly and accompanied them to appointments. Now, and then in the course of 2000, the claimants befriended several youths, allowing them to use their flat where the latter generally misbehaved and engaged in drug taking and underage sexual activity and storing stolen goods. In October, T became aware, this is T again, that the claimants were being exploited by the youth using the flat, and also learned that the husband had been seriously assaulted by one youth in a fast food restaurant. T reported matters, this is letter E. T further regulatory matters the following month with council housing officers, and it was really alleged that T had failed to take appropriate steps. And one can see that if one looks even at that bald recitation of facts, that one could arguably say that that was an assumption of responsibility by T on the argument that one can find a responsibility where somebody does something. Held, allowing the appeal that whether a common law duty of care was owed by a public authority to protect another from the deliberate wrongdoing or action of a third party depended upon the existence of a situation in which the law readily understood that the authority had a responsibility to take care to protect others from the risk. that the authority would not be held to assume such a duty merely by doing what a statute required or by acting under its statutory powers, and that it had actually carried out acts or entered into relationships or undertaken specific responsibilities giving rise to the duty. It was only in such a case that it was fair, just and reasonable to hold the authority owed the duty that the instant case was not one in which the council had control over the claimants, nor had it created or increased the risk to them, nor was it a case of assumption of responsibility, unless it could properly be said there was a voluntary assumption of responsibility, that the circumstances show that the council's social services and housing departments were seeking to carry out their statutory duties and no more, and no one assumed a relevant and specific responsibility for the claimant's safety. So, highly relevant, we submit to the submissions that we are making here. Can I take the court to 981? Paragraph 63. In their written submissions on the decision in the Mitchell case, Ms Gumble and Ms Whitcomb submit that this case falls squarely within Lord Brown's example of the cases where the defendant assumes specific responsibility for the claimant's safety. In summary, they submit that by October the council had recognised the real danger X and Y were in, recognised the extreme vulnerability of X and Y, and recognised that they could not be protected in the premises, that they needed to be moved, had taken steps to achieve a move for them, and knew that X and Y were relying on the council to achieve such a move. It is submitted that those factors give rise to a duty based upon an assumption of responsibility to take reasonable steps to remove them into temporary emergency accommodation. They were in breach of their duty in failing to do so. The assumption of responsibility is put in this way. There was an existing involvement, an assumption of responsibility, in that the council had assumed the task of providing social support for X and Y, the children, and of providing suitable and safe housing. In addition, they had assumed responsibility for rehousing the claimants and the children in the emergency situation that arose, and they had taken a number of steps to do so, but ultimately failed because of a lack of coordination. It's further submitted that the case of X and Y involved a family with known vulnerability. They were in a position, there was a heavy degree of reliance, it is said, by vulnerable adults who were known to be unable to report to the police or resist the exploitation of the gang of youths. Then, the important paragraph 65, so there's plenty of assumptions of responsibility relied on there by learned friends. We are not persuaded that those considerations lead to the conclusion that there was an assumption of responsibility or some other special factor which might give rise to the imposition of a duty of care owed to the claimants. It appears to us that the principal difficulty facing the claimants is their essential complaint is that the council was not exercising its statutory duties and powers properly, which the cases show is not sufficient to give rise to such a duty. Something more is required. Yet both the Social Services Department were simply trying to exercise their statutory powers, no more and no less. We submit that is wholly analogous to the facts of these cases, and this decision has been specifically endorsed by.
Well, there are two differences, aren't there? The first difference is that the danger came from people outside the family, and the second is that there was no reliance on the council's functions under the Children Act. I mean, those might not make a difference, but they are.
There are different facts, of course.
No, not different facts, different legal framework.
Yes, but in a way, I mean, the fact that the context in which the social workers were engaged, whether it was under the Children Act or not, if it was under the Children Act, in a sense, the position would be stronger, perhaps. But here we have allegations that by being involved, there was an assumption of responsibility. And I read out passages in which there were a number of different circumstances which were said to constitute assumption of responsibility.
So this is like Poole, because the danger is coming not from people in the family, but from people outside. Would you accept that?
It is like Poole, but as I submitted earlier, we submit that there's no distinction drawn in Poole between whether the danger comes from outside or from a visitor or from a wicked uncle who turns up or from gangs who it's known that the children frequent with. So one shouldn't draw a line between something in the home, because who knows who might be coming into the home. So that our submission is that there is a difference, but it's not a material difference from the legal analysis.
This wasn't a strikeout, was it? This is a full trial.
It was a full trial.
Yeah.
Yes. And the statutory provisions in respect of which arose in this case are summarised at 966, and as Milady says, 67. They are under the 1948 Act and
And the chronically sick and disabled
yeah,
persons Act
1970.
and the Housing Act.
Yes, it's all helpfully set out.
And community care, provisions about community care.
Yes, there are a considerable number of various interlocking duties which apply to the very vulnerable claimants in this case.
And is it your submission that the Children Act duties are no different?
Well, they obviously are different, but the principle that we extract from this case,
Not substantially
no,
different.
it is not materially different.
Not materially different.
And one final question. Is it right to take from paragraph 90 that there is a ruling by this court that the relationship between a social services employee and the people that they're trying to help doesn't fall within the categories of relationship like healthcare and professional? That seems to be the gist of 90, but I haven't read this case.
No, Your Lordship has actually anticipated the very next
sorry.
paragraph I was taking.
I'm so sorry.
Okay, we're coming to 90 now.
Yeah, beg your pardon.
No, not at all. As already indicated, we have taken the above substantially from the findings of the fact by the judge. The question is whether it's correct to hold on those facts that the council assumed responsibility to the claimants so as to impose upon them a duty to take reasonable care of them by removing them from the flat to temporary emergency accommodation. We answer that question in the negative essentially for the reasons we've already given. As we see it, both the Social Services Department and the Housing Department were seeking to carry out their statutory functions and no more. There was no one who assumed responsibility of the kind referred to by Lord Hoffman in Gorringe, such as might arise from a relationship of a doctor and patient. Nor was there anyone who fell within the categories identified by the House of Lords in Mitchell. There was, for example, no one in the council who created the danger faced by the claimants or assumed specific responsibilities for the claimants' safety. And they say we have reached a different conclusion, 91, from the judge, essentially because he did not approach the matter as one of assumption of responsibility. But having concluded the test of reasonable foreseeability was satisfied by asking whether there was sufficient relationship of proximity and concluding that there was, and then by asking whether it was fair, just and reasonable. And one feels some sympathy for the judge here. This was perhaps the orthodoxy which might have seemed to prevail, but it's no longer good law. He then considered whether it would not be fair, just and reasonable, having regard to the number of other law considerations summarised above. Of course, where the judge also went wrong was using a comparo analysis, which you don't do unless it's a truly novel situation. As to those considerations, we make only these comments. The judge did not consider whether the council assumed responsibility. There was an important difference between a case where children assert that a duty of care is owed to them and a case like this where the claimants are adults. So there is that distinction, my lady is right. Although we would not take this point too far because the vulnerability of the claimants here is undoubtedly a relevant factor. Local authorities have specific obligations in respect to the children under the Children Act, which are different from those which apply in respect of adults. For example, there are statutory duties to protect children from harm which may lead to care proceedings, and indeed to the local authority having parental responsibility. It was not successful, it was in breach of that. As to the principles in Smith, we've already addressed the correct approach. I don't think any trouble to give you right to that point.
Yes, well, that does endorse my lady's point. And how would you characterise the difference between the obligations in Hounslow and those under the Children Act, which the master rolls?
Well, ultimately, there are various steps which the local authorities in either context could have taken. What we get from this case, and of course it's been specifically endorsed by Lord Reed, is that when acting under a statutory scheme, whatever the nature of that statutory scheme is, there will not ordinarily be a duty of care in the absence of an assumption of responsibility. So in here, the local authority could have taken various steps, albeit under a different statutory umbrella, but there is no material difference in the analysis.
I mean, the Section 17 duty under the Children Act is pretty similar to the statutory duties under consideration in this Hounslow case.
Yes.
But as Master Rose actually said, the statute duties under the Children Act are more extensive.
They're more extensive in the sense that they give more detail as to what powers are. I know your Lordship's only too familiar with what the powers of the local authority are.
Yeah.
What the difference does not, on the other hand, mean that the court, in deciding whether there is a duty of care, adopts a different approach.
Yeah.
And that's
So the fact that there are different statutes does not change the
no. And I mean, and we get that from Poole, of course, where Poole specifically uses these paragraphs and this case as being all authority. Perhaps it would be helpful if I went back to
Yeah, I think it will be helpful to look how Lord Reed now deals with
yes,
and Michael.
yes.
I assume we are moving towards the conclusion of our submissions, I assume.
We are moving.
We're not before the short. I'm not going to certainly guarantee you in 5 minutes.
I probably got another half an hour.
Okay, that's fine. It's our fault, not yours. Rather, it's the complexity. It arises out of the complexity of the arguments.
I thought it might be useful just briefly to go back to Poole to pick up these references.
Having rather peremptorily grumbled yesterday to Miss Gumble about the extent to which she was relying on authorities or going through the authorities, and you having assured us we weren't, we have spent most of that morning going through the authorities. That just shows how difficult it is to predict what's going to happen. Where do you want us to go in Poole now?
Just looking for the reference to X and Y and the...
Is it in 71?
Yes, it is. Thank you very much. It's yes, it's a particular passage, in fact, my Lord referred to. The decision, paragraph 71, it's page 531 of the bundle. Case with similarities to the present case. It was held that local authorities, departments had not assumed responsibility, and then he gives the quotation from Sir Anthony Clark's paragraph 70, not one of responsibility unless it could properly held to be voluntary, since the claimants amounted to no more than the council had failed to move them into temporary accommodation in breach of its statutory duty, and the exercise of its statutory powers, it failed because none of the statutory provisions gave rise to a private law cause of action. The correctness of that decision, of these decisions, is not in question. So he also considers Michael, and Robinson is the other case, which perhaps I can come to briefly after the short adjournment, although only briefly. That really helps in terms of what the proper approach to whether there's a duty of care is, and I needn't spend too much time. The other cases I'm going to refer to briefly are a case called Tyndall and a case called Blewett, which there has been reference. It may be that the court hasn't read Tyndall. It won't take very much time, but it's a fairly recent decision of this court about what Poole meant. So,
okay, well, I haven't read Tyndall. Is it in the bundle?
It's in the bundle, yes. It's
right, tab 22.
okay, that's the case. So I'll be referring to that and Blewett briefly, and then I will come back to try and summarise our cases. I haven't referred, I think, only one occasion to our skeleton argument, but our skeleton argument may perhaps make a little more sense now I've spent some time trying to answer the questions I've been posed.
All right. Would that be a convenient point?
Indeed.
All right. Well, shall we resume at 2 o'clock?
Yeah.
Right. Just a moment.
Report-wise,
you thought?
Tort is the authority.
What?
I'm glad I picked up on